Matter pertains to Itanagar Bench for the delivery of judgment. Criminal Appeal Jail 28 of 23. Criminal Appeal Jail 6 of 23.
Yeah, no, improvisation. I was in this one. Yes, yes. We have found no reason to interfere with the judgment and order of conviction and sentence passed by the special court in Sessions case number 221/2023. The criminal appeals being bereft of merits, therefore fails, accordingly affirming the judgment and order of the special court and maintaining the order of conviction and sentence, the criminal appeals are dismissed.
I'm praying for listing for motion lordship. I'm praying for listing for motion lordship.
FT matter.
FT matter lordship. Masterpiece.
Lordship, item number 2, kindly
Yes.
pass over the matter. My senior TN Srinivasan health condition is not well.
Yes, Mr. Sharma. Okay.
Whole pending matter,
you-
my lord.
Huh?
Whole pending matter.
Next time you prepare yourself.
Next time.
Next time.
After weeks, my lordship. So treatment is
Your
being
good name, please.
in Islam.
Mr. N. Islam, the Learned Counsel, the paying for the petitioner has submitted that Mr. T.N. Srinivasan, Learned Counsel, who is leading him in this case, is in this post and has and on that ground, he has sought for an adjournment of the case for a week. Post of Mr. G. Sharma, Learned Standing Counsel, NRC,
FTN nurse.
FTN NRC, and Mr. R. Kolita and Kolita, Learned Counsel on behalf of Mr. A. Ali, Learned Standing Counsel ECI, and Mr. P. N. Sharma, P. Sharma, Learned Senior Additional Senior Government Advocate for the Government of Assam, for the respondents are present and have the Learned Counsel for the respondents have highlighted that the petition is of the year 2019, post of. In view of the fact that in view of the ground cited for adjournment, the request is accepted. List the case on
1206. 12 June.
yes.
Yes.
May it please the lordship. I'm praying for listing of an alia lordship,
For
for orders lordship.
give it to the courts.
DPO.
Daily list for motion. Item number 1.
May it please lordship. Lordship, this matter may fix for admission hearing lordship. 2019 matter lordship.
Yes, Mr. Sharma,
Lordship.
whole matter.
Whole pending matter, my lord. Thought that may be fixed. TCR has already been received. Lordship.
Interim order is there.
Interim order is there.
Record receipt.
Yes, lord.
Heard Miss
On behalf of A.M. Ahmed.
P. Das.
BDAS.
P. Das, Learned Counsel, on behalf of Mr. A.M. Ahmed, Learned Counsel for the petitioner. Mr. G. Sharma, Learned Standing Counsel, NRC and Home for the respondent number, Home Department for the respondent number 2,
2, 5, and 6.
2, 5, and 6, Mr. N. Kolita. Mr. P. Sharma, Learned Additional Senior Government Advocate for the respondent number 3, and Mr. P. Kolita learned counsel on behalf of Mr. A.I. Ali, standing counsel ECI for the response number 4. First of, there is no representation on behalf of the response number 1. Today on call, first of, para. The seal is made in this petition to an order stroke opinion. Dated 30/11/2018. Passed by the learned member, Foreigners Tribunal Court, Gwalpar, Assam, in FT case number FT within bracket Z-4 bracket close M stroke 10 stroke 17 in reference to IMDT case number 107 stroke 2000 PS 53. As the ECR is received and all the respondents are represented, and the repetition is of the year 2019, let notice be issued. No, let notice be issued. So as the repetition is of 2019, the notice is made returnable on so and so. An endeavor will be made to for final consideration or repetition on the returnable date at the admission stage. The interim order passed earlier shall continue till the next.
2007 July. Item number 3.
Will challenge to an order FB 41.
Yes, Mr. Sharma. ECR is received.
Yes, Lordship.
Order. Then for disposal of the admission stage,
Lordship.
BP Bora petition.
Last data. It will be so.
And Kolita
Young sir.
on behalf of Mr. A.I. Ali, Learned Standing Counsel, ECI.
Actually, yes, I will say.
For the response number 2, Mr. P. Sharma, Learned. Oh, Mr. Z. Sharma, Learned Standing Counsel, NRC and Home Department. For the response number
She.
3, 4,
6.
6, and 7. And
Yes,
Mr.
sir.
P. Sharma, Learned Additional Senior Government Advocate. Assam for the response number 5. There is no representation on behalf of the response number 1 today on call. Can you say? Can you say?
Deploy.
Item 4. Item number 4.
None. There is no representation on behalf of the petitioner today on call.
Records received.
Yes, Lord.
Mr. Z. Sharma. On behalf of the petitioner and the response number 1 today on call.
Respondent number 2, 3, 4, and 6.
2, 3, 4, and 6. Z. Sharma. And Kolita, 6. And P. Sharma, 5 are present. In view of non-representation on behalf of the petitioner and call the case, for instance, justice, be listed again on so and so.
860806. For admission, item number 5.
May please your lordship. So item 5 and 6 may take after some time. My senior SK Usami is in the way, lordship.
You don't know whether this man will survive or not.
After 10 minutes, lordship.
Only one item next.
For hearing, item number 7. Item number 7 for hearing.
Prayer question.
Oh, my sir. 9 also. Seven.
What to do? After review, once it was disposed of.
Lordship,
Review position. There is no representation on behalf of the petitioner today on call. Mr. Z. Sharma, petitioners. Z. Sharma, NRC home, for the husband number 2 and 4, and Mr. P. Sharma, additional senior government officer for the husband number 3 are present. In view on representation on behalf of the petitioner today on call. Comma. Let the case from for rental justice be listed again on so and so.
16/6. 16 June. Timing matters. Item 5.
I'm sorry, lordship. This appeal is basically filed. Lordship, we have been regularized earlier by the authority as per order of the Writ Appellate Court. In Writ Appellate Court, they have submitted that our service will be regularized. I can hand over a list of dates, Lordship, for page 77. Lordship got it. Page 80 it start. May I read, Lordship? Relevant portion, Lordship. Learned single judge has found that the order of appointment have been issued illegally, and
And
that
what order? Let us have it full.
finally, Lordship will find
Page
relevant
80,
81.
80.
Page 81.
Now let us read from 80. It is a case of the appellants were teachers.
It is the case of the appellant that the appellants were appointed in the year 1999 and earlier year too. The appointments of the said teachers come to be terminated as being illegal, and that the appointment order issued by the District Elementary Education Officer, Block Elementary Education Officer in Nalbari District were illegal. Therefore, the termination order were issued by the Director of Education BTC. This court in WBC case number had found that the termination order are illegal and remanded the matter to follow the principle of national justice. Director of Education relied within the exercise and again terminated for the second time, giving some reasons. Agreed by the said order, appellant have filed the writ petition. Learned single judge has found that the order of appointment have been issued illegally and the order of termination is legal. Hence, dismissed the writ petition. Agreed by the said order, the appellant filed these appeals. It is submitted by the counsel for the appellant that the appellants herein were receiving salary up to 17/10/2006 and thereafter the termination was effected. BTC as well as the government of Assam took a decision to regularize all those teachers who were service and regularly receiving salaries up to 17/10/2006. In the first phase of the exercise, it is submitted that 221 teachers have been found to be eligible for regulation as per the above norms. It is contention on the appellant that the appellants are also similarly placed and they should also receive the similar treatment of the law. The counsel appearing for the BTC submits that policy decision is taken that the person to receiving regular salaries from the month of March 2006 would be regularized and the implementation of the policy is in process. Government of Assam has also agreed to the said policy. In view of the above submission, writ appeals are disposed of with a direction to respondents to effect regulation as per policy decision and all those eligible teachers who were regularly receiving salaries up to 17/10/2006. Needless to say that if any appellant is aggrieved in the decision making with regard to the tenure of their service rendered and receipt of salaries, they can approach this court by separate petition. Thereafter, Lordship, the petitioners reinstated service, page 87. All the petitioners, this order, Lordship, to find page 87. In pursuance to the Honorable High Court's order, judgment and order dated 6/2/2015 that I have read, writ appeal number, batch of the events or the miss case number Iman, BTC, consequently BTC Executive Council meeting resolution number 401 Iman, the department meeting department education Iman, a consonance with the approval received from the BTC fight Iman, Somen Gueri, who was terminated from service, fight Iman, issued from this and is hereby withdrawn. And his service is regularized, reinstated as assistant teacher, Iman number, LP school and grade pay Iman. All the five has been regularized by same order. From up to page 91.
Yes.
Thereafter, Lordship, petitioner has been joined in the school, page 92 onwards. They have joined in their respective schools. Lordship, thereafter, again separate regulation order has been issued, page 96. In pursuance to power conferred upon the Director of Education, BTC, Secretary BTC, Assam, communicated by Iman, said fill up post has an approval of Finance Department by Iman, which is validity period extended by the Government of Assam, Department Iman. Page 96. Okay.
Regularization.
Again regularized. All the five petitioner. Read the plan.
There is a reference also.
Lordship.
The earlier one.
Now, Lordship, we have approached this court by writ petition for a direction because from 2015 to 2022, we have not been paid salary.
Approval.
We are working. All the writ petitioners are working in the same school. Writ petition number 113 of 2011, page 113.
Page?
Page 113.
Yes.
All the five writ petitioner has approached the Honorable Court for direction to pay the salary.
There is a prayer.
Prayer is, Lordship, 134. Page 134.
Yes.
Lordship, we prayed that petitioner should be paid salary from the date of reinstatement in service. Page 134. We prayed for salary from reinstatement of service by the authority after withdrawal of the termination order till second regulation. After second regulation, petitioner is getting full salary. Lordship, that order has been, Lordship, the writ petition has been disposed of by common judgment. Lordship will find the common judgment 299. Various writ petition has been tagged together and ultimately writ petition has been dismissed on the ground that petitioner initial appointment was illegal and irregular, and that is why they are not entitled for salary.
That position reached finality.
Reached finality. But the
Thereafter, some policy was taken
policy was taken.
to regularize them. Otherwise, original appointment was illegal.
They have
That
stated
did not march.
that is not much.
It is clear
Clear.
as water that by the division bench order, the original illegality
Was not
in
decided.
appointment.
Ah.
Yes, that attained finality. Right. So just a policy has come into being. So it was, court has said, let you take the decision as per the policy for regularization. So 2015, the first orders of regularization came. Then thereafter again second regularization. Right. This is the situation. And in between, you did not receive the salary.
From 2015 to
15, first regularization and second regularization. You did not receive the salary after first regularization reinstated. Okay.
my case is, Lordship, in this particular case, why we have not been allowed to salary by the Honorable Single Judge.
Now, what is the reasons given?
Lordship will find page 454, relevant portion.
For
Page 454. The finding number Roman 24.
before.
454. Lordship got it? That we have been appointed without creation of post. That is why we are not entitled for salary. Now I will take your Lordship to the RTI information. Lordship will find page 110. Lordship, kindly see 110, page 110. Because all these cases were disposed of without considering the actual fact. Page 110, kindly see, Lordship.
Yes.
Page 110. May I take your Lordship to page 110? That is the RTI information taken by the one of the appellant.
Yes.
Lordship will find with reference to the subject cited above, I have the honor to transfer the reply of RTI as per RTI Act 2005. Required details number 47 various LP school teachers from 359 teachers appointed Iman, listed Iman, and regarding their monthly salary under old pension scheme provision under the date of undersigned. Now Lordship will find the RTI information. Next page, Lordship. 111. Lordship will find name of the school and the name of the appellant. Post creation number, everything is there. Where petitioner has been appointed. And permanent retention was there. Lordship got it. Now, Lordship, another thing is important thing, Lordship. What is the appointment order, initial appointment order? Initial appointment order, Lordship will find they are stipended teacher. Page 21. Lordship will find page 21. Lordship got it, page 21.
Which year? 1999.
1999.
Oh, 1999.
Stipended
All
teacher.
things happen in 1999.
99. Stipended teachers, and after completion of basic training, they have been given the regular scale of pay. All the person has completed basic training. I have enrolled the basic training certificate also.
Yes, madam, who are there?
Already
Very
similar appeal has been
complete
admitted. Already appeal has been admitted.
Which is the order?
Lordship, I could not collect.
Yes, madam, any similar writ appeal has been,
Sir, at this moment, I have no information regarding this, Lordship.
do you have the number?
No, sir. I have got the information of it. But in this particular case, my fact is totally different. We have the creation number, post creation number and everything. And Lordship Purnima Hojai case, this court has already held. The stipend teachers are entitled for Lordship the pension and everything, not the this other teachers. That is
Lordship, in page
Purnima Hore's case.
Well, you should notice that this is hard.
Lordship, in the judgment, impugned judgment, Lordship, it has been specifically stated by the Honorable Court, Lordship, in page 456, last page, Lordship.
Hmm.
If Lordship permits me.
Yes.
In last page 456, last para, in the case in hand, the policy of regularization arise out of a situation when the petitioner's initial appointments were held to be illegal, and it is the BTC authority in its wisdom decided to regularize the services of 221 such teachers and subsequently of the petitioners. Therefore, such legal right to get salary, pension, and other service benefits shall arise on due regularization.
Now they are saying that page 110,
456.
they 111, they are saying that the
As
post-
the appointment was illegal during that period, so
madam,
Lordship,
they are saying that page 111, that the post was created in 1992, wherein they were engaged. That is just other case which they have tried to develop.
yes, Lordship.
Part the stress skills and learn what happens. And Miss N. Chaudhary, who is for
Resolution 2 to 6.
elementary education. Madam, please respond. Miss so-and-so Learned Standing Council, Elementary Education Department for the response number 1. Miss N. Chaudhary, Learned Standing Council, BTC for the response number 2 to 6. Any finance? Where? This inter-court appeal is against a common judgment and order dated 14/7/2015, rendered in a writ petition including a writ petition WBC number 5176/2016, wherein the appellant's hearing were the writ petitioners by the common judgment and order dated so and so. The batch of writ petition was dismissed. Para. In the writ petition, WBC number 5176/2000 so and so. The prayer was for direction to the respondent authorities to pay the salaries of the appellant's petitioners with effect from 5/10/2015. Postal. Para. It is a case of the appellant's petitioners that subsequent to an order dated 6/2/2015 passed in WA number 182 2013 and WA number 4 2014, comma, the appellant's petitioner aim to be regularized in the post of assistant teachers by different orders, comma, all dated 1/10/2015, which is in the scale of pay with grade pay, post of. Subsequently, comma, by another set of orders, comma, the appellant's petitioner were shown to be regularized in the post of assistant teachers. Another set of orders dated 39/2022. The appellant's petitioners were shown to be regularized again. Post of. It was during the period between 1/10/2015 there, during the period from first regularization order of 2015 and the second regularization orders of 2020,
39/2022.
39/2022. The appellant's petitioners were not paid the salaries. Post of, the learning is just dismiss the writ petition, finding that at the time of first regularization in the year 2015, there was no creation of post. And as such, the regularization orders passed in 2015 were not in any sanction post. And in view of such finding, comma, the salary to the appellant's petitioners during the period for first regularization and the second regulation were denied. Post of para. Why I'm referring to
Page
the
112.
information obtained under the Right to Information Act 2005, comma, as available in page number
110.
110
110.
110 dash 111, comma, the appellant's petitioners are contending that the post where they were originally appointed were created in the year 1992, and as such, the finding reached by the learned single judge is not tenable. The matter will require consideration, issue notice, returnable on so and so. As Ms. Tekaniki, the standing counsel. Elementary Education Department. Has appeared and accepted notice on behalf of the respondent number 1 and Ms. Choudhury, and standing counsel, BTC. Has appeared and accepted notice on behalf of the respondent number 2 to 6. Formal increase dispense with extra copies of readable. Memo of appeal along with an excerpt are to be furnished within 2 working days. The learned counsel for our appellants shall furnish a copy of the memo of appeal along with an excerpt to the learned standing counsel, finance department for service of notice upon the respondent number 7 within 2 working days from today.
Obliged.
Your
Respondent number 4, it's your B Choudhury.
You were different, with not BTC. Let us see what is respondent number 4. Ms. Choudhury, you are for whom?
ONGC.
BTC?
Yes, Lordship.
2 to 6 or 4 is to be excluded. All part of BTC.
2, 3, 4, 5.
2,
6.
3, 2, 3, 4, 5, 6.
Yes, Lordship. Yes,
You,
yes.
Obliged.
oh, notice has already been issued.
Lordship.
Notice issued on the last occasion, issued, Lordship, notice.
The respondents are to ensure that its response, if any, are filed on or next before the state. I thought that notice has not been issued. It's already filed. Yes, I know. Part 20. And if they want to traverse that book contention, one by the night council for the and their responsibility. Are filed before the next day of it. It's like this. After it.
Obliged.
1707. For orders, item 6.
Lordship, 117 days delay, same order, Lordship.
Yes, madam.
No objections, no objection.
Art, the SK. Before the applications. And yes, spending also eliminated the department for the police party number 1. And yes, and to agree. Who's understanding also with this system? No, there's 4 opposite sign, 5. It's. This is on the other. The instances. Again, under. Or the indication 1963 is filed against Corporation of Lake of 117 is filing the company against a common judgment. So the company in the case is against a common judgment in order to 47,000 rupees paid. Passed by the rest of including how many?
Lordship, total petitioner is Lordship,
How many people you are filing a appeal?
Lordship,
You have combined.
Lordship, combined is Lordship.
I don't think you can.
So because common judgment, Lordship,
No, that is not the procedure. Court has the discretion
Lordship.
pass a common judgment. But the appellants cannot join together after filing separate petition in a recovery. I don't think that is not the procedure.
I'll see, Lordship.
Because they were prosecuting separately. The repetition was in one repetition and another batch of repetition in another repetition. Join together in retable, that is not the procedure. Board has the discretion to pass a common judgment. But all the repetitions should file separate appeals.
Lordship, fix another day, Lordship, I'll verify, Lordship. If Lordship. Only to avoid Lordship the multiplicity of appeal, that is why.
That is also. It is not a multiple proceeding. That is
The procedure.
joining of multiple cause of action, which is not permissible. Because
But here cause of action is common judgment.
cause of action is common, but I don't think it is the proper procedure. High Court rules will indicate.
I'll verify the rules, Lordship.
Including WBC number. Zero 2017. Number 5741 2017. WBC number 3273 WBC number. Oh. Examiner counsel has sought listing of the case after week in order to address on the maintainability of the accompanying GTP. Wherein the petitioners, appellants, applicants, where the petitioner in 4 separate petitions have joined together to file a combined appeal.
Well, I'm sorry. I was appearing in item 7, I do not reach in time. It has been adjourned, I'm told.
16-6.
16-6.
16-6. Trigger it immediately, 16-6.
My lord, huh?
Today,
I thought earlier ones will take some time, so I was very lazy. You can't go. Well,
Items 1 to 4.
Wait, please.
what is Mr. Roy?
Same.
Just a minute. এইকেইটাও দিব বাকীকেইটাও দিব বাকীকেইটা ফাইলত Yes, what is the grounds on which
Lordship, aware that of the four petitions, in items number 1, 2, and item number 4, the ground of rejection, Lordship, is solely the nature of the offense. That is the heinous crime.
tell a name?
Yes, Lordship.
So that will be-
Ganesh Bhumij.
Hmm?
Ganesh Bhumij. Item
Ganesh
Bhumij.
Bhumij.
It's petition 6283, Lordship, of 25.
Bhumij 6283. His alias the name doesn't match with his main name.
Yes, Lordship.
Hmm?
Madhu Karma.
One, then
Then, Lordship, Samsul Mia. Petition 5946 of 25.
5946 2025. And next,
Lordship, Holiram Bordole.
Holiram.
Bordole. Yes. That's petition 524 of 26.
524 of 2026. What is the ground?
Lordship, the ground is that they have
Heinous.
heinous offense.
Okay. And Moinuddin,
The ground, Lordship, is that the opinion of the convicting court is not clear. Petition 5999 of 25.
opinion of
The concerned court is not clear.
just a minute. Ganesh Bhumij was decided on
22/7/2024, Lordship.
22/7. Connection with, okay, serial number, any idea?
Lordship, I think that is in that bundle.
Okay, just a minute. Ganesh Bhumij. $75. Then Samsul Mia 21. Holiram Bordole was decided on
He was considered on 2 dates, Lordship. First on 24/6/25.
just 22/7/2024. Now Holiram
24/6/25.
24/6/2025.
Thereafter, Lordship, on 19/3/26.
19/3/2026. Serial number. So his proposal was considered along with many others.
Many others. On
32
19/3/26.
plus 58,
Yes,
which will be about 90.
yes.
Okay. And on 22/7/2000. So in case of 3,
Yes,
it was deferred by 2 years.
right.
So time is coming up.
Yes, Lordship.
It is
Lordship, in
almost
fact-
near. It is near.
22/7/26.
So it will be very near. Yes. What about this when opinion of court is not clear? CRPC and
Yes,
BNSS. I think section 432 subsection 2.
yes, Lordship. That is regarding the opinion of the presiding court.
And what is the corresponding provision in BNS
I'll have to check that.
432? Subsection 2.
Subsection 2.
Please read.
Yes. Wherever and whenever an application is made to the appropriate government for the suspension or remission of a sentence, the appropriate government may require the presiding judge of the court before or by which the conviction was had or confirmed to state his opinion as to whether the application should be granted or refused, together with his reasons for such opinion, and also to forward with the statement of such opinion a certified copy of the record of the trial or of such record thereof as exists.
And what is the corresponding provision in BNSS? Now it has been replaced.
Yes, Lord.
432. 432. 432. 473. Is verbatim?
Lordship, I had compared it, so no material change, Lordship.
I think verbatim.
Yes, Lordship.
473 subsection 2. So what weight?
Yes, Lordship, that is covered by Ramchandar, if I may place that, Lordship. Lordship may have para 25.
Ramchandar.
Two aspects in this judgment. One, that the opinion
Para 25.
25 and 26, Lordship, relevant to 26.
Yes.
May I read, Lordship? In Sriharan, the court observed that the opinion of the presiding judge shines a light on the nature of the crime that has been committed, the record of the convict, their background, and other relevant factors. Crucially, the court observed that the opinion of the presiding judge would enable the government to take the right decision as to whether or not the sentence should be remitted. Hence, it cannot be said that the opinion of the presiding judge is only a relevant factor, which does not have any determinative effect on the application for remission. The purpose of the procedural safeguard under section 432(2) CRPC would stand defeated if the opinion of the presiding judge becomes just another factor that may be taken into consideration by the government while deciding the application for remission. It is possible then that the procedure under section 432(2) would become a mere formality. However, this is not to say that the appropriate government should mechanically follow the opinion of the presiding judge. If the opinion of the presiding judge does not comply with the requirements of section 432(2), or if the judge does not consider the relevant factors for grant of remission that have been laid down in Lakshman Naskar, the government may request the presiding judge to consider the matter afresh. Thereafter, Lordship, the conditions are laid down.
Para 27.
27 as to what Lakshman
Lakshman Naskar.
Yes. As well as Jagdish, Lordship.
Do you have Jagdish? with
Yes,
you?
Lordship, I have.
Let us say.
Yes.
These two Lakshman Naskar.
Yes, I have. It was yes. It is. Lordship may take up Lakshman Naskar, para 6, Lordship.
There was a state government guideline.
Yes, Lordship.
On
that
that
is-
basis, the report was called for.
Yes.
But it has been appropriately considered in Ram Sundar.
Yes. Lordship, thereafter in Jagdish.
That was these 4-5 factors
Yes.
on the basis of guidelines, but
Yes.
that has given a stamp of approval in the
In the subsequent decisions. In Lakshman Naskar, it was in guidelines of that particular
right,
case.
but Ram Sundar, it has been made
Yes, even in Jagdish.
factors for consideration.
Yes.
Okay.
Even in Jagdish, Lordship, that view has been taken that
Where is Jagdish para?
para 46, Lordship. Placitum F, Lordship, 46. May I read, Lordship?
Yes.
At the time of considering the case of premature release of a life convict, the authorities may require to consider his case, mainly taking into consideration whether the offense was an individual act of crime without affecting the society at large, whether there was any chance of future recurrence of committing a crime, whether the convict had lost his potentiality in committing the crime, whether there was any fruitful purpose of confining the convict anymore, and the socio-economic condition of the convict's family, and other similar circumstances. Thereafter, in that sequence, Ramchandra comes, and the factors are thereafter in para 14 of Ramchandra. And 15.
And what about heinous offense?
Yes, Lordship, heinous offense as a sole ground has been covered recently in a judgment called Rohit Chaturvedi.
Honorable Justice Nagaratna.
Yes, Lordship.
Just
Lordship,
a
I'm
minute.
only
Just a
relying-
minute, just a minute. Previous. It has in- this I might have this one. Detail. ইয়াতে আছে নেকি? ইয়াতে ক'ত আছে? Yes, I do. ইয়াতে আছে নেকি? What is the name of the case?
Rohit Chaturvedi, Lordship.
Hmm?
Rohit Chaturvedi versus State of Uttarakhand.
Rohit Chaturvedi.
Yes.
It was said.
Jill.
Should we have para 7?
আৰু এটা আছে কবি নেকি? আৰু এটা আছে নেকি কবি? আৰু এটা আছে নেকি? Yes.
Lordship, para 7, if I may read.
Para
7.
Yes.
Reverting to the present case, a faint ground invoked by the Respondent Union of India in support of rejection of the petitioner's plea for premature release is that the crime committed by the petitioner was a heinous one. We wish to make it clear that in a constitutional polity governed by the rule of law, the denial of remission cannot rest solely on the ground of heinousness of the crime. As we have already stated above, remission is not an extension of the sentencing process, but a distinct executive function concerned with the present and future, namely the prisoner's conduct, evidence of reformation, and prospects of reintegration into society. To predicate its denial only on the heinous nature of the offense is to collapse this distinction and to reconvert remission into a retrospective reaffirmation of guilt, which the criminal justice system has already adjudicated upon. The gravity and heinousness of the offense stand exhausted at the stage of sentencing, and the judicial determination of punishment necessarily incorporates these considerations. A criminal justice system that refuses to look beyond the gravity of the offense of the offender's transformation will betray its reformative ideal, particularly at the remission stage. Justice does not permit permanent incarceration of an individual in the shadow of their worst act. The nature of the offense cannot, therefore, be the sole ground for denying remission. Emotive retribution is a course incompatible with constitutional values. The decision on remission must emerge from a holistic assessment of the prisoner and after balancing societal interests with the prisoner's right to be considered for release on fair and reasonable criteria. Thereafter, as Lordships had observed on the last day, the court considered the case in
That goes against Ram Sundar.
Yes.
Ramchandra. Because this is an executive function, but the factors are required to be considered that mandamus cannot be issued or certiorari cannot be issued. Okay.
with respect to factors to be considered in the manner. There is one recent judgment in policy strategy of bail by
Justice Oka.
Justice Oka, yes.
Oh, I have. Oka. Policy decision. Policy guidelines.
Yes, yes. Also, Lordship, in one of these petitions, Lordship had seen that order in Sonadhar versus Union of India was relied upon. So that Lordships is subsumed in this that has been decided together.
Sonadhar.
Sonadhar, Lordship. If Lordship has in-re policy strategy, it also decides SLP 529 of 21.
This is Sonadhar.
This is Sonadhar, Lordship.
Okay. Sonadhar was disposed of.
Was no, Lordship, it is pending. It remains pending.
Para
17, Lordship. (17 and 18), Lordship, if I may read. The power.
This is with regard to grievous
Lordship,
or
it is in general directions.
general direction.
There are general directions that reasons ought to be given. It must be communicated through the DLSA. And also an SOP was introduced through NALSA, by which a right to appeal through legal aid was also given.
Para.
Lordship, the directions are at para 21. Relevant to this case, Lordship, are D, F, and G.
You said para 17?
17 and 18.
Okay,
And-
let us see.
Yes. Para 17, Lordship. The power to grant premature release must be exercised in a fair and reasonable manner. It affects the convict's liberty guaranteed under Article 21 of the Constitution. Therefore, the requirement of recording reasons, either for granting or rejecting the prayer for permanent remission, will have to be read into the provisions of section 432 of the CRPC and section 473 of the BNSS. Principles of natural justice must be read into the provisions of section 432 of the CRPC. In any case, in the case of Bilkis Yaqub Rasul, in paragraph 222.8, this court held that the reasons for grant or refusal of remission should be clearly delineated in the order. Therefore, the requirement to record reasons exists. Brief reasons must be recorded, which are sufficient to enable the convict to understand why his prayer for remission has been rejected. This enables him to challenge the order of rejection.
So there is another line of decision, Mr. Atreya,
Yes.
that formation of opinion on the basis of materials
Yes, sir.
and adequacy or sufficiency of formation of opinion is not a matter of which can be subject to judicial review. Now, whatever reason they have said, okay, only concerned court not clear, heinous nature of the crime.
Yes, sir.
Okay.
Because there is no illusion as to whether the materials were even considered.
Regarding those 5 factors.
Yes, Lord.
And what that Mr. Roy referred to?
Lordship, those minutes.
No.
Sangeet versus State of Haryana.
Sangeet was earlier, right?
Yes, Lordship, that has been now subsumed, especially in Swami Shraddhanand and Sriharan. Lordship, there's also one other aspect. With respect
Just
to
a minute, Sangeet. Come to para 64. Sangeet.
I'm not carrying the copy.
Okay.
Lordship, I'm carrying Shraddhanand and
Okay.
Sriharan.
Yes. What other aspect?
Lordship, with respect to item number 4, that is Podiram Borderline. Lordship will recollect that is a case where the death penalty has been commuted
That is in a writ petition.
in a writ petition.
After appeal was dismissed by Supreme Court.
Lordship, after also rejection of the mercy petition.
Yes.
So thereafter, Lordship, in this honorable court held that it will be subject to remission. So that remission was provided for in that particular case. What Lordship Swami Shraddhanand and V. Sriharan says that there is one special category of offense in commutation that can be carved out by a commuting court, whether the High Court or the Supreme Court, by which remission can be denied. When commuting a death penalty, Lordship, the Constitutional Court may hold that.
Yesterday or day before yesterday, something has come up.
Lordship.
That may not be applicable directly, but it says that Constitutional Court can fix
Yes.
the period and with a condition, no remission.
Yes. Precisely, Lordship. That's all.
3 judges bench.
Yes.
Who is the senior most judge, I don't know, but it is bench consists of Justice Sandeep Mehta and Justice Bisnoy.
I'll check it up, Lordship. But
It has
otherwise,
come yesterday.
I'll check it up. Check it up.
There may be more
Yes,
proposition,
yes, Lordship. Check that out.
but where is Mr. Roy? He is conspicuously absent.
I'll inform him, Lordship.
Yes, state council.
Yes. Lordship, may permit me to place Sri Haran, Lordship, that is a constitution bench judgment on precisely this point, whether it can be commuted.
I had that copy, but I misplaced it.
Fine. The issues are framed at para 8.
Para 8. What will be the page?
Lordship, 51.
51. Yes.
Keeping the above factors in mind, precisely the nature of questions culminates as follows. 1. As to whether the imprisonment for life means till the end of convict's life with or without any scope for remission. 2. Whether a special category of sentence instead of death for a term exceeding 14 years can be made by putting that category beyond grant of remission. 3. Whether the power under section 432 and 433 of the CRPC by the appropriate government would be available even after the constitutional power under Articles 72 and 161 by the President and the Governor is exercised, as well as the power exercised by this court under Article 32. 4. Whether the state or the central government have the primacy under section 432(7) of the CRPC. 5. Whether there can be two appropriate governments under section 432(7). 6. Whether power under 432(1) can be exercised suo motu without following the procedure prescribed under 432(2). And 7. Whether the expression consultation stipulated in 435(1) really means concurrence. Lordship,
Which one is relevant for our case?
1 and 2, Lordship.
1 and 2.
1 and 2.
Because 8.6,
Yes.
somewhere I have seen that it cannot be so moto,
Yes.
definitely by an application,
By an application.
by the convict.
That has somehow, to some extent, been modified by Justice Okar's judgment, which seems to say that no application is required. But this is
But some other judgments say must be an application.
this one is
And
a-
what is Sangit, that is also by 2 judgments.
Yeah. But in our case, Lordship, applications were made by us in all the 4 petitions.
So that point is not relevant,
Okay.
8.1 and 8.2.
Yes.
Okay. Where the answer, para?
Para 176, Lordship, is the majority opinion.
176.
(137) page number.
1.
37.
Yes.
177, Lordship, is the answer. Para
177.
Yes. Imprisonment for life, in terms of section 53 read with section 45 of the Penal Code, only means imprisonment for the rest of the life of the convict. The right to claim remission, commutation, reprieve, etc., as provided under Article 72 or Article 161 of the Constitution, will always be available, being constitutional remedies untouchable by the court. We hold that the ratio laid down in Swami Shraddhanand 2, that a special category of sentence instead of death can be substituted by the punishment of imprisonment for life or for a term exceeding 14 years and put that category beyond application of remission, is well founded, and we answered the said question in the affirmative.
What does it mean?
Lordship, Swami Shraddhanand had carved out a special category in cases of commutation where a court is faced with death penalty or life. It can opt for a third option wherein it commutes the death sentence to life but without remission. So that was held to be permissible in this case.
What is the ratio done? Beyond application of remission.
Yes, it could be withdrawn by the commuting court. While commuting a death penalty to life, it could withdraw the benefit of remission under 432 only. It therefore says, however, Article 172 and 161 power will remain. Only the power within Section 432 for the appropriate government could be withdrawn by the.
This 161 or 72 is governor and president.
Yes.
Now, instead of date, it can be substituted by the punishment of imprisonment for life
Yes.
or for a term exceeding 14 years, and put that category beyond application of remission. And it is held permissible. And in Holiram Bodule's case, it is subject to the rider that remission.
Remission was given. It was not withdrawn.
So that opinion holds the pillar, don't it?
Yes.
So far, Holiram is concerned.
Yes.
Okay. Yes.
Lordship, what I seek to argue, therefore, is that in the case of Holiram, the court had exercised explicitly that opinion that remission would be available to him, and therefore he could have been considered. Only on that point, Lordship, when submitting this. I have also Swami Shraddhanand, but Lordship, it has been discussed.
Now, what is the second question answer?
Yes.
Okay, 179 or what?
Yes, yes. The exercise of power under sections 432 and 433 of the CRPC will be available to the appropriate government, even if such consideration was made earlier and exercised under 72 by the President or under 161 by the Governor. As far as the application of Article 32 of the Constitution by this court is concerned, it is held that powers under section 432 and 433 are to be exercised by the appropriate government statutorily, and it is not for this court to exercise the said power, and it is always left to be decided by the appropriate government. That is the second issue. Lordship, there's also the suo motu power that has been held to be inapplicable. That can
Anyway, that situation is not here.
not yet.
There is an application. What is the office memorandum?
Yes. Lordship, we take up the first page.
What is office memorandum date?
6/10/2015.
6/10/2000.
In the first petition, Lordship, that is at page 39.
That is Ganesh Bhumij.
Yes, Lordship. What is it?
Page
39.
just what is that they referred? This criminal appeal Sangeet.
Yes, Lordship. This is Sangeet.
This is Sangeet.
Yes.
This was done in exercise of power under Rule 571 of the Assam Jail Manual.
Jailman. That, if I may please, Lordship.
Guideline.
The process is provided in page 40.
Yes. So para 6 factors.
Yes.
Para 6.
Para 6. It contains
So
the condition.
this is of 2015.
50.
So much water has flown thereafter.
Yes.
So these two factors are frail, 75 years, and
Which is conduct within the
with excellent track record,
Yes.
but not regarding the societal factors, whether he can be assimilated into society. Those
Great,
factors
great.
are not germane for under this office memorandum.
Which is also, as far as the jail manual is concerned, there are certain rules as to how this is to be done. Even their lordship, if only the computation of remission, how that is to be done is provided. But as far as factors are concerned, at least in light of the new standards, it is slightly deficient. I'll place the
This
rules.
jail manual is under what? This is a manual only,
Yes, lordship.
or in exercise of some power?
No, lordship, it is originally it was a jail manual as executive instructions. Thereafter, the Assam Prisons Act of 2013 has come, which has a savings clause, as
Yes.
section 92, which saves the rules which are
Is
not
it?
in good. Yes, lordship. She may have the act. Jail manual.
Jail manual hindi আছে এটা আছে ইয়াতে আছে saving clause jail manual আছে এটা সব
Page 131.
section
Section 92. 131 of the book, lordship.
92. Yes.
May I read, lordship? 92, repeal and savings. The Prisons Act 1894 and the Prisoners Act 1900, along with the amendments made therein in their application to the state of Assam, and the Good Conduct Prisoners Probational Release Act 1938 are hereby repealed. Notwithstanding such repeal, any rule or appointment made, order or direction issued, action taken, or anything done prior to such repeal under any of the acts so repeal shall, insofar as it is consistent with this act, be deemed to have been made, issued, taken, or done under the corresponding provisions of this act, and shall continue to have effect accordingly, unless and until superseded by any rule or appointment made, order or direction issued, action taken, or anything done under this act.
So,
On- So it may have page. May have page 390, the book. This is essentially a compilation of
Basically,
various statutory rules we have made. So,
but it does not have any beginning or,
yes,
huh?
but with respect to the chapter on remission, it refers to the statute under which it is made.
Which part?
At page 390, Lordship will find Rule 325.
Rule?
325. Chapter 19, the remission system.
325.
Yes,
Remission system.
yes. You will see there's a note. Rules made by the state government under section 59(5) of the Prisons Act 1894 as amended to regulate the shortening of sentence by the grant of remission. That lordship goes back to section 92(1) of the Prisons Act 2013.
Prisons Act 1894.
Yes. So these rules were made under that Pre-Independence Act. Rule 571, Lordship, that was referred to in the OM. That is part of this chapter. So there's also one aspect I'll have to point out here. Lordship may have 327A.
Yes.
It reads, Lordship, exclusion of life sentence awarded after commuting death sentence. No remission shall be earned in respect of any life sentence awarded after commuting a death sentence. This shall come into force immediately. By that logic, Lordship, Holiram Bordole's case would have come into the picture. However, Lordship, it seems to have been since deleted. So 327A is no longer part of the.
Deleted.
Yes, Lordship, that Lordship will find at Rule 571. That's page number 461 of the book, Lordship.
571.
571.
Rule 570.
Rule 570.
Rule 570. Yes.
Lordship will see sub-rule 4, release of life convict. The superintendent shall submit to the Inspector General for every half year ending 30th.
Rule 571.
570.
Okay.
Sub-rule 4, that's at page 461.
Yes.
Yes, Lordship, that provides for the release of life convict, how that is to be done, and the procedure. What I am on, Lordship, is the note appended to this. There is a note, Lordship.
Yes.
The case of a life convict who is entitled to earned remission shall be dealt with under clause 1 above on completion of 14 years imprisonment, including any remission earned under the rules. And if he continues in prison, his case shall be dealt with under clause 4 above on completion of 20 years imprisonment, including any remission earned under the rules, and thereafter on expiry of every half year ending 30th June, 31st December, till he continues in prison. 2. The case of a life convict who is awarded a life sentence after commuting that sentence and is therefore debarred from earning any remission under Rule 327A since deleted shall be dealt with under clause 1 above on completion of 14 years actual imprisonment, and if he continues in prison, his case shall be dealt with under clause 4 above on completion of 20 years actual imprisonment, and thereafter on expiry of every half year ending 30th June, 31st December, till he continues in prison.
Deleted.
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 However, I could not find a note in the original.
No, it is. This is in page 5, rule 571. Rule 571 is in page 460. Four 327 A. As per 327A,
Yes,
it
Lordship.
was inserted by government notification in 77.
Yes.
But when it was deleted, it is not there.
Is not there in the book. Lordship, just my understanding is also that perhaps, Lordship, there is a power of commutation at the hands of the government. It perhaps was a reference to that, as opposed to commutation at the hands of the court. And secondly, Lordship,
Secondly, Sriharan, I think, has dealt with the issue.
yes, because otherwise, with respect to the court, that power is always there.
No.
There's also another aspect, Lordship, that in continuation.
Suppose what 327 says?
327A, Lordship, says
327. Okay.
it says, Lordship, no remission shall be ordered in respect of any life sentence awarded after
Just
commuting.
I got 327. Okay, awarded after committing a death sentence.
Commuting a death sentence.
Now, C1 says whether imprisonment for life or for a term exceeding 14 years, and whether to put that category beyond application of remission is for the constitutional court to decide.
Yes,
And in case of Holriam Bodoloi,
yes,
it has been decided
It has been
subject to
decided.
remission.
yes, precisely.
And this. Yes.
And Lordship, thereafter, the OM of 2015 is actually a continuation of this. That in the sense, Lordship, in Ramchandar, jail manuals and their status has been dealt with. Lordship may just have one paragraph from there. It may some help.
In
In Jagdish. My apologies.
Jagdish.
In Jagdish.
Cool. Is Jagdish.
Para 24. Previous case of Sadhu Singh is decided, discussed, Lordship.
Yes.
In Sadhu Singh versus State of Punjab, this court examined the nature of the provisions contained in para 516B of the Punjab Jail Manual, which provided for remissions, etc., and executive instructions issued by the Punjab government from time to time, and came to the conclusion that the jail manual contained merely executive instructions having no statutory force. Thus, it was always open to the state government to alter, amend, or withdraw the executive instructions or supersede the same by issuing fresh instructions. But the court observed as under, any existing executive instructions could be substituted by issuing fresh executive instructions for processing the case of lifers for a premature release. But once issued, these must be uniformly and invariably applied to all cases of lifers. A similar view has been reiterated by this court in Balwan and Lakshman Naskar.
This was in 1977,
Yes.
and its office, those are
2015
executive instructions.
instructions. But Lordship, the idea seems to be
And this court had whether earlier held it that to be Assam Jail Manual or Assam Police Manual are set of executive instruction. Somewhere it is
we had looked at
held.
Yes.
Just
Lordship.
find out.
Yes, I looked it up.
And just a minute again.
Yes.
So this OM may be an executive instruction.
Yes, it is an executive instruction, Lordship, but my contention, Lordship, is that
But there is
no, Lordship, it is exercise of powers under Section 432. My contention, Lordship, is that the Prisons Act cannot confer remission. It can only compute the earned remission. Thereafter, an order has to be always made under Section 432 in exercise of that statutory power of the state for remission to actually apply and for the person to be able to avail the benefit. The Prison Act and the rules can only compute it, Lordship, is my submission.
yes, somewhere it is said additional remission because this is indefinite. The
You are right.
imprisonment in the case of life imprisonment is indefinite.
Yes.
Basically, it is for the remainder of the life.
Exactly.
So, life imprisonment means he has to die there inside the prison. But still, additional remission by that way, it can be reduced, but not be less than 14 years.
Yes. What Lordship Sriharan seems to say is that the remission under the rules is in essence a notional remission that is computed. Only once an order or exercise of Section 432 happens, only then it crystallizes. The OM of 2015, Lordship, in my humble submission, is in exercise of Section 432. It formulates that policy. So, since it does not bar, and also given Sriharan's observation regarding commutation, this Lordship will not come in the way, even if not deleted.
Constitutional, Sriharan is constitutional court,
Yes, 5 judges.
5 judges,
5 judges.
and that is binding on all authorities under Article 141 or 2?
One.
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 Okay. We put it that way.
Lordship, also 2 other additional submissions. With respect to the case of Samsul Mia, there is, Lordship, a ground of parity available, given that the co-accused has been released. To that extent, Lordship will note that there is a factual difference with respect to
Samsul Mia,
Samsul Mia.
parity. Yes.
Lordship, that also has been considered by the Supreme Court in a similar case where the law has not been declared, Lordship, in all fairness, but however, factually that was given. Because, Lordship, interestingly,
But this other one was roped in by aid of 34 in
Yes.
case of Samsul Mia.
yes,
But still a consideration can be given or not.
yes,
Because he is on a higher pedestal.
yes,
His guilt is on a higher pedestal, Samsul Mia, than the co-accused. He was roped in by virtue of Section 34. Yes?
Lordship, in this case, Jaswant Singh was the co-accused in Ramchandar. He had thereafter approached this court. And then court on the Supreme Court, Lordship, has considered at paragraph 8 and 9. Since the case of the present petitioners is also similar to the case of the co-accused Ramchandar, inasmuch as the presiding officer's opinions contained in the letters dated so-and-so.
Paragraph you said?
8, Lordship.
8.
8 and 9.
Hmm.
Lordship will have 8. Since the case of the present petitioners is also similar to the case of the co-accused Ramchandar, inasmuch as the presiding officer's opinions contained in the letters dated so and so do not contain reasons with regard to the factors to be taken into consideration, as laid down in Lakshman Naskar versus Union of India. We propose to pass similar order as passed in the case of co-accused Ramchandar. In that view of the matter, it is held that the petitioner's applications for remission are required to be reconsidered by the respondent authorities afresh. Accordingly, we direct the Special Judge Durg to provide an opinion on the application of the petitioners afresh, accompanied by adequate reasoning, after taking into consideration the relevant factors that govern the grant of remission as laid down in Lakshman Naskar. I am saying, Lordship, because essentially all the factors that were taken into consideration with respect to Samsul Mia, the DC report, the SP report, as well as the presiding officer's opinion, Lordship, are in a sense the same with regard to the same case. Lordship, that ought to be also considered. Lordship, and one last factual aspect with respect to the case of Holiram Waterway. Lordship has noted that the OM of 2015 provides for individuals who are aged, who are 75 years or more.
Yes.
Lordship, his age as of the date of filing was 76 years old. He was 76 years of age.
Okay, Horiram Murray, 70.
6 as of the
6
date of
years.
filing.
$76.
He's also a patient of his heart issues, etc. Lordship, his health is also not in the best.
Those are factual, but this patient,
Yes,
age is
but at least age was within the scope of consideration. Lordship.
what we propose, we put it day after tomorrow. Mr. Roy is not there. Whatever you have said, we'll streamline and
Very well.
record your submission on that day.
Yes.
Munna Moiduddin Sheikh. What is it of recent? Tinita. Note down one Shiva Kumar, 2023, 9 SSC. 2023, 9 SSC, 817. Para 14. Right?
Look it up.
Day after tomorrow.
Obligation.
Heard Mr. Yatfield and a counsel for the petitioners at some length. Those stuff. Submissions are not complete. First of moreover, Mr. S.S. Roy, learned state council, learned junior government advocate for the state respondents. He is absent today. Release the cases again on Thursday for further hearing.
Obligation.
Ah. Okay.
May it please the Lordship. Lordship, in respect of item number 5, yesterday we had circulated an adjournment slip. Lordship.
Yes, yes.
Lordship, senior counsel has sought for a short accommodation, Lordship. He's out of station. Any time, Lordship may fix the matter.
So two things here, Your Honor. Firstly, I think the adjournment slip has been signed by respondent number 4 and not not CCI. So 2 and 3 have not signed it. That may just be noted. And the second aspect is any short date, because actually I'm under a lot of pressure to have this expeditiously disposed of, whichever way.
But that may not be possible because sometimes counsel for the petitioner respondent is out of station. But this court will be out of station now.
Very well, Your Honor. That is, I think, Your
All right.
Honor's prerogative.
So
and
it will be.
Your Honor must.
It
So
will be-
July, Your Honor?
I've been told that I'll be out of station. I'll be made to
Very well, Your Honor.
be out of station. So in that case,
No, absolutely, Your Honor. We will not want to impinge on that. 15th or
this is
16th?
not a case which can be hired from outlying banks to virtual.
No,
mode.
not at all. Not at all.
Because this brief is very bulky.
It is indeed.
It cannot be taken or it cannot be say downloaded.
Absolutely, Your Honor.
So maybe after
15, 16 July, Your Honor, may consider? Or any other date?
July then.
End of July? 28th,
July, take something on 21st.
21st, 22nd, Your Honor?
It will be Wednesday.
21st.
Lordship, let it be on a hearing date then.
That is what?
Or maybe
21st.
23rd. I'm actually,
23rd.
I'm in a part third on the 21st
Okay.
and that may continue. That is my only difficulty.
Okay. Mr.
B. Sharma, Lordship.
B. Sharma, learned counsel, appearing for the petition has submitted that Dr. A. Saraf, learned senior counsel who is leading him in this case, is out of station. And for that purpose, a mentioned memo has been circulated yesterday, post up. Where Mr. D. Das, learned counsel for the learned standing counsel, CCI, has submitted that he has not, however, been informed about the proposal for adjournment. Post up. Be that as it may, he has agreed for short accommodation. Post up. Having regard to the prayer for adjournment, and as the learned counsel for the parties have agreed on 23/7/2006, list the case on 27/6.
And Your Honor may permit me to mention it for listing at 2 o'clock on that date. Deeply obliged.
Obliged, Lordship.
Deeply.
For hearing, item 6.
Yes,
I am for the respondent number 4.
yes. We'll only start, not finish.
We can't finish it today. Can't finish.
We'll only start so that I can have a brief idea about what is the case about.
Right.
One is IA.
Who are you?
Who are you?
One is
Who are you?
IS 575, another is 2
Two I. Sound equal. We can put a second. This one. Okay, one is, okay, 2276. What is the main case?
Main case is
Company petition,
Company
Buddha
petition.
Brothers. Buddha Brothers.
Bura Brothers.
So, applicant in IA 2276 is the respondent there.
In 2276.
Basically, it
respondent.
is Buddha Brothers.
Yes.
Let us have the main one, then I can understand.
Yes, but only
The offshoot of the main.
yes, but these offshoots will really determine the main.
But let us have a brief idea.
Sure.
What is the main case?
Main case, my lord, application under section 272 of the Companies Act for winding up of the company. As a creditor, I have filed this application.
As a
Winding up.
creditor.
Winding up of the respondent company.
272.
Yes.
Companies Act.
Company.
An application and sections Pura Brothers. Dolo Tea Company. Dolo Tea Company.
May I read, madam?
Yes.
272 petition for winding up.
You are referring to
Section 272, madam.
270. Yes.
This is prior to amendment of 2016, my lord, because this petition is filed on 2015.
Hmm.
So I'm reading the provision of 2015, my lord.
2015.
15. It is in the footnote also, in the mains.
Footnote.
272 petition
So
for
prior
winding up.
to amendment of in 2000.
2016. There was a changes in 2016, but this petition is filed on 2015.
Prior to amendment in 2016.
Yes, my lord.
This petition was filed in
2015.
okay. Yes.
Now, section 272, petition for winding up. Subject to the provision of this section, a petition to the tribunal for the winding up of a company shall be presented by the company B, any creditor or creditor, including any contingent or prospective creditor or creditors. I am on this B.
272.
272, 1B.
1B.
As a creditor, I have filed this application.
Why High Court? It says tribunal.
It is after 2016. At the time of 2015, my lord, tribunal was not set up. Although act was there, but tribunal was not set up. It was set up in 2016, my lord.
Tribunal was?
NCLT, National Company Law.
No, but at that time also, in prior to amendment,
Yes, my lord.
tribunal word was there.
Word was there. From 2013, the word was there.
And tribunal, you say tribunal was not.
2016, from 2016.
So when there is a specialized tribunal, why this company petition is pending here?
That's why I filed this application, my lord. My lord, after 2016, there was provision in the Companies Act that any pending cases pending in the High Court, in certain circumstances and the stage, those cases are liable to be transferred. So earlier, there was a one stage that up to this stage, if cases are pending in the High Court, those may be transferred. I am following on that also. Number two, Your Honor, 2018, in 2018, there was again amendment in the Companies Act, where it was specified if any of the party file an application before the Honorable Gauhati High Court, those matters are required to be transferred to the NCLT. And IA 2575 is that application. In both the situation, my case is required to be transferred to the NCLT. 2575 IA.
2575.
My lord.
For transfer.
For transfer.
And why it was pending since 2022?
It's my lord. The order is reflected.
And the another I is pending since 2021.
So may I, Lordship may take 2575 for the time being. IA. It's a small petition, my lord, 10 pages only.
Yes.
My lord, may I take your honor to paragraph 2,
2575.
257.
Okay, okay. Does not look like it is a small petition.
257.
Okay.
Their reply is heavy.
Bigger than your
My lord.
petition.
My petition,
Hmm.
may I take your honor, lordship, to para 2. That will be clear the proceeding of this case, my lord. Para 2.
Yes.
Yes. My lord, applicant as petitioner filed a company petition bearing number 3, 2015 on 26/3/2015. Now, your honor, my lord, opposite party respondent number 1 to 3 filed their affidavit in opposition on 26/10/2017. Affidavit in reply filed by the applicant petitioner on 26/3/2018. Rejoinder by opposite party respondent company on 15/6/2018 and again second rejoinder on 26/6/2018. Thereafter, my lord, the opposite party respondent number 1 to 3 filed an application challenging the maintainability of the said company petition, which was registered as IA number 2276, that is on 10/12/2021. Thereafter, my lord, the opposite party respondent number 4 filed his affidavit in opposition on 8/4/2022. This is important, your honor. 8/4/2022. And my lord, this application I have filed on 22/8/2022. Now, what are the grounds of this application? Why this is required to be transferred to the NCLT? That I have written in my paragraph number 3. Of this petition, my lord.
Yes.
Applicant begs to state that in view of the substitution of section 434 of the Companies Act 2013, while notification number this and this, 2016, my lord, issued the central government read with companies transfer of pending proceeding rules 2016. It was inserted, my lord. As published by notification number this issued by the central government, all company cases pending before this honorable court in which the winding up petition have not been served on the respondent till 15/12/2016 are required to be transferred from High Court to National Company Law Tribunal for dealing with in further proceeding at the end of the tribunal. So here, my lord, if they have not appeared, if the notice is not served till 15/12/2016, this was the condition, my lord. In the instant company petition, my lord, it is apparent on the face of the record wide order dated 18/2/2022 thereof that the petition of the case was not served on the respondent number 4 till that date, that is 18/2/2020, and accordingly, as per Rule 5 of the company's transfer of pending proceeding rules 2016, read with section 434 of the Companies Act 2013, the same is required to be transferred to the NCLT before Gauhati
Who is
bench.
respondent number 4?
So that is the one ground, my lord.
No. Who is respondent number 4? You say
Respondent
respondent 1 to 3 has filed their affidavit of opposition.
Respondent number 1 to 3 is the company, registered office, corporate office, and branch office. And respondent number 4 is the director, my lord.
But company
One
has
of the
been served.
directors. One
Company
of the
has been served. Company has been served.
Yes, company is. Company is, sir.
Company is will be represented by the managing director.
That is the reason, my lord, that this case was not transferred suo motu by this honorable court to the NCLT. That may be the reason, my lord.
But suppose just what is the hierarchy? NCLT. Thereafter, if NCLT decides against it, any appeal?
Appellate authority.
Appellate authority is
NCLAT.
appellate tribunal. Thereafter?
Thereafter, High Court and Supreme Court. If
So-
low point is there, High Court, otherwise Supreme Court.
Okay. What are the provisions?
My lord,
What are the provisions in the Companies Act
company
regarding that road?
transfer regarding this transfer.
No, not regarding transfer. The hierarchy. Hierarchy. Have you understood? From NCLT, where appeal lies, which provision?
Will be governed as per the Insolvency Bankruptcy Code, my lord. By way of the Insolvency Bankruptcy Code.
This Companies Act does not provide
No,
for.
no, my lord. Separate code is there.
Yeah, and see it here.
That is the Insolvency and Bankruptcy Code.
Because now Lordship, Insolvency Act has come in for these matters.
Okay. But still it is National Company Law Tribunal is mentioned here,
Yes, Lordship.
Companies Act.
Yes, Lordship. But apart from this, apart from winding up, other provisions are also there in the Companies Act.
Just minutes.
So jurisdiction of the High Court per se has been taken away, except when some reference is made.
So otherwise, Companies Act 2013
13.
speaks about constitution of
NCLT.
NCL. And it speaks about appellate tribunal also.
Yes, ma'am.
Yes, yes.
Let us see. It is 292, section 2, subsection 90. It speaks about tribunal. Now, appellate. Appellate tribunal. 2 within bracket 4. Appellate tribunal. Appellate tribunal. Let us have section. I am looking at it just because I am not very familiar with it. Section 408. What is section 408, Mr. Chopra? Section 470 to 408.
408 regarding Constitution of National Company Law Tribunal, my.
Okay. National Company Law Tribunal. Then Constitution of Appellate Tribunal. 40.
12. 409 is the qualification.
410.
10 is
410. Appellate Tribunal.
Constitution Appellate Tribunal.
And where is the jurisdiction? Clause 420. Being heard. An appeal from orders of tribunal. So section 420. Section
421 also.
21 also. And any jurisdiction clause? 422.
Appeal to the Supreme Court.
That is Supreme Court.
And 423. What are the matters which can be filed? It is not there.
My lord,
Matters in the sense?
That tribunal will decide this kind of application, this kind of subject matters. It is not there specifically.
Specifically not there. If not, as far as this is concerned, Insolvency Act has come now,
Okay,
2016.
408, just
2016 Insolvency Act has come.
408.
Orders, it is mentioned
No,
as
in
order.
408 it says,
Orders.
408, it says to exercise and discharge such powers and functions as are conferred on it by or under this act or any other law for the time being in force. So IBC has come in the meantime. That is in 2016.
16.
So conferred by this Companies Act as well as any other law.
Yes.
Okay.
Now, my lord, 434 is important. Companies Act, section 434. Transfer of certain pending proceedings.
434.
Of the Companies Act.
Yes. On such day as may be.
As may be notified by the central government in this behalf, all matters proceeding or case pending before the Board of Company Law Administration constituted under subsection 1 of section 10E of the Companies Act immediately before such date shall stand transferred to tribunal, and the tribunal shall This is regarding that company law administration. Any person aggrieved by any decision or order of the company law board made before any date may file an appeal to the High Court. This is regarding separate, my lord. I am on C.
C.
C. All proceeding under the Companies Act 1956, including proceeding relating to arbitration, compromise, arrangement, and reconstruction, and winding up of companies. This is winding up of company, my lord.
Sell.
Pending immediately before such date, before any district or
Shall
high court
stand.
shall extend, transferred to the tribunal, and the tribunal may proceed to deal with such proceeding from the stage before they are transferred. Provided, this proviso are important.
Provided that only.
Only such proceeding relating to the winding up of companies shall be transferred to the tribunal that are at a stage as may be prescribed by the central government.
Right.
So that stage is important now, my lord.
If I only such other than. But that. I find that only such was.
May I read second provision, my lord?
Ah.
Second provision, provided further that only such proceeding relating to cases other than winding up, for which order, this is other than winding up, not requirement. Provision number 3, provided also that all proceeding under the Companies Act 1956, other than the cases relating to winding up of companies, that is also other than winding up. Now, 4, my lord. Provided also that proceeding relating to cases of voluntarily winding up of company, where notice, this is regarding voluntarily winding up, not required. 5 is important, my lord. Provided further that any party or parties to any proceeding relating to the winding up of companies pending before the any court, immediately Ordinance 2018 may file an application for transfer of such proceeding, and the court may by order transfer such proceeding to the tribunal, and the proceeding so transferred shall be dealt with by the tribunal as an application for initiation of corporate insolvency resolution process under the Insolvency and Bankruptcy
Provided
Code.
that any
Which
party.
proviso, my lord?
Provided either that any party or parties to any proceeding relating to winding up of companies pending before any court immediately before the commencement of the insolvency and insolvency. In the light of these provisions, why this was pending? I didn't know.
Time is taken,
Huh?
my lord.
No, Lordship. Law did not permit transfer of this. I will place that. Because it is not just any proceeding will be will be transferred by just passing an order. Because we again have the company's transfer of pending proceedings rules 2016, which has been formulated under section 434. So these transfer is as per the rules formulated by the central government. So these rules come into play. Then again, we have the rules regarding service of notice. All these things will come into play, Lordship. So it's not just, it'll just be, notice is not served. Another thing is that one very wrong statement has been made here, that notice is not served on the respond number 4. In fact, notice was served on the respond number 4. In 2015 itself, the records would show. It was only refused. Notice.
No, just to understand.
Yes. Lordship,
Companies Act, just a minute. This 434.
Yes, Lordship.
This has been brought in 2016.
Right.
This
And
fifth proviso-
whether any rule
Yes.
framed under Companies Act can supplant the Act.
No, there's no supplanting. It's not that.
Because say, I'm just putting a query,
You're correct.
434C,
Yes.
right, on such date as may be notified by the central government. in
Yes.
this behalf.
Yes.
It says, see, notification will be any notification.
Yes, ma'am. There is.
All proceedings under Companies Act, including proceeding relating to winding up of companies, pending immediately before such date, shall stand transferred to the tribunal. This is one. And the fifth proviso, first proviso,
First provision. That is the first provision.
only such
Where
proceedings
the stage is
relating to winding up of companies shall be transferred to a tribunal. That is stage as may be prescribed by the central government. Then last, provided further that any party to parties to any proceeding may file an application.
Yes.
So one is for so moto,
Also,
the other is on an application, may file an application.
that is from 2018.
That is from 2018. Now,
So for the first provision, my lord, under that first provision, this notification was issued. This is called
transfer of so and so and so.
Transfer.
Companies Transfer of Pending Proceeding Rules 2016.
Yes, that's what I was facing for, Your Lordship.
That is under the first provision. So our cases fall under 5, my lord. Because 4 is for voluntary winding up and 5.
Your case, you
Look
say,
at the 5.
what is the date? 15 December. 15 December.
15 December 2016.
2016.
Yes, fine.
Now, which rule you are saying?
Serial number 5, my lord, point number 5 of this notification. Transfer of pending proceeding of winding up on the ground of inability to pay debt. My petition under this. Here,
All petitions relating to winding up.
You're under
Under-
434? 5.
5. All petitions relating to winding up under clause E of section 4.
Clause E, where is clause C or E? Clause E. Something is wrong. Clause E.
It should be clause C, Lordship.
C.
Should be C.
C.
Clause C.
Yes.
Of pending before the High Court.
Pending before a high court, and where the petition has not been served on the respondent as required under Rule 26 of the Companies Rules 1959 shall be transferred to the bench of the tribunal established under subsection 4 of section 419 of the Act, exercising territorial jurisdiction, and such petition shall be treated as application under section 7, 8, and 9 of the code as they may be dealt with in accordance with the part 2 of the code, provided that the petitioner shall submit all information other. So this is regarding the stage, my lord. This is, I have filed the transfer petition on 2 grounds. One is under this, and another is 5th provision, which is inserted in 2018, my lord.
Which 5th provision?
5th provision. And it is already settled by the Supreme Court, my lord. I have the authorities. Whether this rules is applicable to so far 5th proviso is concerned, it is already decided by the Supreme Court. I am placing that. Restriction under Rule 5 and 6 of the Company's Transfer of Pending Proceeding
Just a
Rules.
minute.
My
403.
Oh, that one. 2000.
Caledonia.
Caledonia.
2021.
Caledonia.
2021.
Harry.
2 SCC.
2021.
Dr. Harry to let go. Yes.
My lord.
It means this will let go. Yes.
Whether restriction under Rule 5 and 6 of the
Which paragraph
Company's.
you are reading?
The paragraph is, my lord, (13). The main issue which determined by this apex court, my lord, the main issues that arise for consideration in this appeal are paragraph 30, my lord.
13.
13.
Hmm.
What are the circumstances under which a winding up proceeding pending on the file of a high court could be transferred to the NCLT, at whose instance such transfer could be ordered? That was the point, my lord, and it is
Yes.
decided in paragraph number 26 and 46, my lord.
26.
26.
Disseminate will be 25. Here will be 25, keeping in mind.
Yes.
Apart from providing for the transfer of certain type of winding up of proceeding by operation of law, section 434(1)(c) is also give a choice to the parties to those proceeding to seek a transfer of such proceeding to the NCLT. This is under the 5th proviso to clause C. Now, my lord, kindly take paragraph number 37.
Yes.
After so interpreting rules 26 and 27 of the Companies Code Rules 1959, this court pointed out of Forge India Limited that when the code was enacted, only winding up petitions where no notice under Rule 26 was served were to be transferred to NCLT and treated as petitions under the code. However, it is important, my lord, after section 434 was substituted by a new provision under the Act 31 of 2016 and the 5th proviso was inserted by the Act 26 of 2018. The transfer of the winding up proceeding, even at the instance of the party or parties to the proceeding, become permissible. This change of position was also noted by this court in Port India Limited. So my submission, my lord, after that insertion, that the rules earlier 2016 was not applicable. And the concluding is paragraph 46, my lord.
Just a minute. Okay. Yes, paragraph.
And paragraph 46, concluding paragraph. 46, my lord. Therefore, we are of the considered view that the petitioner herein will come within the definition of the expression party appearing in the 5th proviso to clause C of subsection 1 of section 434 of the Companies Act 2013, and that the petitioner is entitled to seek a transfer of the pending winding up proceeding against the first respondent to the NCLT. It is important to note that the restriction under Rule 5 and 6 of the Company's Transfer of Pending Proceeding Rules 2016 relating to the stage at which a transfer could be ordered has no application to the case of a transfer covered by the 5th proviso to clause C of subsection 1 of section 434. Therefore, the impugned order of the High Court is this is the finding. So my humble submission that for the first proviso, that rule was there. But after insertion of 5th proviso, that restriction is not.
So that High Court rejected the transfer application. Supreme Court said that the decision was flawed. Okay. Anything else?
Yes. They have taken the plea that this is the discretionary of the court for the transfer, and that discretion should not be evoked in the present circumstances. Now, what is in what circumstances that discretionary power can be used by this honorable court so far? This paragraph that is also settled by the Supreme Court. It will action is path. Copy देते हैं.
Yes.
Para 11, my lord. Para 11. Roman 4. That becomes a clear upon the reading of the three
Just a
judgments.
minute, I have not reached para 11.
Para 11, Roman 4.
Para 11, Roman 4.
No.
Para 11. Caledonia. Para 11, yes,
Roman format.
yes.
Therefore, what follows as a matter of law is that even post admission of a winding up petition and after the appointment of a company liquidator to take over the assets of a company sought to be wound up, discretion is vested in the company court to transfer such petition to the NCLT. The question that arises before us in this case is how in such discretion be exercised. It is completely here. What happened, my lord? Even the liquidator is appointed, but Supreme Court is finding given in para 22, my para 20.
Yes.
Given the aforesaid scheme of the winding up under Chapter 20 of the Companies Act, it is clear that several stays are contemplated with the tribunal relating to the power to control the proceeding in winding up petition even after it is admitted. Thus, a winding up proceeding where the petition has not been served in terms of Rule 26 of Companies Code Rules 1959 at a pre-admission stage, given the benefit result of the application to the court, such winding up proceeding is compulsorily transferable to the NCLT to be resolved under the code. Even post issue of notice and pre-admission, the same result would ensue. However, post admission of a winding up petition and after the assets of a company sought to be wound up become the custodia legis and are taken over by the company liquidator, section 290 of the Companies Act 2013 would indicate that company liquidator may carry on the business of the company so far as may be necessary for the beneficial winding up of the company and may even sell the company as a going concern. This is important, my lord. So long as no actual sale of the immovable or movable property have taken place, nothing irreversible is done which would warrant a company court staying its hands on a transfer application made to it by a creditor or any party to the proceeding. It is only where the winding up proceeding have reached a stage where it would be irreversible, making it impossible to set the clock back that company court must proceed with the winding up instead of transferring the proceeding to the NCLT to now be decided in accordance with the provision of the court. So whether this stage is irreversible stage that is to be find out by this honorable. Here in this case, my lord, now liquidator is appointed, nothing that irreversible stage is reached. Even my lord, certain high court has given that it is so moto transferred, even without application.
Yes, and thereafter, yesterday I was reading one that even after admission, the stage of hearing also it can be remanded back. Otherwise. Okay, you respond on next date.
No, there are very many counts, very many circumstances. So I will respond next. Lordship, when will that be? If Lordship may give a date.
Right issue. It will taste your pain, you know. Can be on 18 June, I am told.
Can it be before 10th, my lord?
No,
10th is too early.
This court is not sitting.
So 18, 19th, Lordship, it's not really possible. Maybe thereafter, 23rd of June.
Thereafter, it will be okay.
Vacation.
How long it will take? It depends upon you.
23rd, Lordship.
I have heard Mr. Chopra almost. He may
Yes.
supplement.
Yeah,
But
because
the only thing is how you can carve out an exception.
Yeah, that I'll show, Lordship.
Only you have to
Actually,
carve out
the
an
petition itself-
exceptional case of exception.
So, Lordship, the other petition, Miss case was been filed, that to show the company petition is not maintainable, is barred by limitation. It is actually barred by limitation.
I have given my reply on that. That
I-
matter also be to be taken care by the NCLT.
Not necessarily, because in this, Lordship, 23rd of June,
Can it be before that? Because it will be just before vacation, I'll be, and that will be motion days. No, not possible to be taken up.
16th, Lordship.
Okay, we can have a try on 16.
16. My lord, on
I am
16.
told that I'll be sent for 1 week. So in that case,
She will be
I
back.
might be available on 16.
She will be back.
If it is not available, then
And go after the
On 16,
vacation.
I may not be available. It's in
if it requires your assistance, then I will defer the matter.
my,
Okay.
Obliged.
At VK Chopra
yes.
for the petition in so and so. For the petition and Miss M. Hazarika, Senior Counsel, estate by Miss Learned Counsel for the respond number
4.
4 only. And which for the company?
1 to 3.
Yes, what do you want to say? Mr.
He had-
Khandelia, Learned Counsel for the respond number 1 to 3.
We'll address on the.
Next day.
We have filed, why that is necessary, we'll address on the next day.
No, Mr. Khandelia, you are the company.
Yes, yes.
Actually, I'm not a necessary party, even he admits.
No, but you are under the company
No, and I'm not, I'm no longer there.
and you are no longer there.
Even when they filed the application also, I was.
So
not-
it is Khandelia who has to oppose the application.
So we'll reply on the transfer petition as well as we will address the IA.
Both.
Okay, Z Khandelia 1 to 3. Read the case again. This is the case on
16.
16.
Obliged.
16 June. 16.
Not because to be part heard because it is already assigned to you.
Yes, Lordship.